Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly, once in 2 weeks, a community phone call. You would have heard our disclaimers logging in. This is not an attorney-client privilege call. It doesn't establish a relationship, nor can we guarantee the information that we provide here, but we do our best with what we've got. With that said, I want to get started. Let's see. Did I mention the date? Today is June 25th. June 25th, and I was just looking at the Trump order, the proclamation. That said, let's just go over the frequently asked questions first. What I did was I went over in the few minutes before the call I went over the questions and I marked certain questions as frequently asked so that I can address them first and any follow-ups on those. Then I will go over other questions that are not frequently asked questions. And if I have time, I would love to have many hours to talk with you guys all day, but sometimes you just can't do everything that you want to. I may not have time for new questions, but I'll do my very best for you guys, okay? That said, let's begin with our first frequently asked question. So here the question is from Flower Girl, who says, what happens for religious visas where our premises are still under construction? The petitioner does not conduct any religious programs yet, no other primary office location. Can we file an R1 for a minister for future employment? I haven't really looked at the regulations, but just going by what I remember of several cases that we have done for religious workers, including religious priests, we had a case where the Sai Baba temple was still under construction, but people were doing the kirtans, etc., the worship on a rotational basis on other people's homes while this was being prepared. That case was approved. So as long as you have somebody who can start working as soon as they get in, the fact that you have a primary site which is being built, I think could be accommodated. I would have to review the law. I'm sorry, I don't know the in-depth answer off the top of my head, but I know that we've done this before. *5 if you have a follow-up question on this. Press *5 if you have a follow-up question. On your telephone, press *5. Okay. Let's go on to the next frequently asked question. This is another one we've dealt with quite frequently, and I've actually talked about it in detail several times, but I don't mind addressing it again because it's such an important issue that I am here on H1. My child is, who's now a young man, turning 21 next year. What happens? He would age out of H4. Can he change to F1? Yes, absolutely. Are there any caveats? Not really, but I would make it very clear the reason I'm asking is because he's aging out of the H4. And we've had, in the beginning, we had some issues, but I think over a period of time, it has settled down and you are likely to get the H4 to F1 conversion. And he should be able to do it within the United States. Just make sure that you allow for the fact that sometimes they take many months, 7, 8, 9 months to approve these cases. Right, so I'm looking at what you are saying. You already preempted that question. So I would start about 8, 9 months ahead of time. Whatever I-20 you can get. They're not processing I-20s for fall right now, only for spring. You can check with them. They have their own procedures, but my advice would be to file as early as you can. And that's the best you can do. Because you always have the option, hopefully by that time, if the consulates are back in business, he might be able to travel to Canada or to Mexico to get his F1 visa stamping done. *5 if you have a follow-up question on this. *5. Okay. Let's go on to the next frequently asked question. This is, we have filed so many lawsuits in the last 7-8 months. It's become quite a weird situation. It looks like courts have become a regular part of our immigration process. For Ravi A, the problem is currently on F1, doing second master's degree, got CPT from day one, received H1B approval under consular process. Now, I'm not sure that you have that option, because if you asked for an H1B with a change of status and they said, oh no, CPT is like being out of status, you should file a lawsuit. But if you applied for consular processing, which I have never done to begin with, I always tell people, and it turns out in retrospect that was very good policy, apply for change of status. Even if you believe government is not going to give it to you, why not? Do it. Because if you don't fight, you already lost. If you fight, at least you have a chance you might win. Therefore, applying for a change of status always makes sense in my opinion. I think the only way I can advise, well, hang on one second. You might have another option. I just thought of that. Even if they did not apply for a change of status the first time around, now that the premium processing is open, you can apply H1B again. You're not subject to the quota anymore, and ask for a change of status within the USA. You can do that. So now they might not give it to you because of the CPT, which they consider to be illegal. And frankly, I think that is going to be a very difficult case for the government to win in court. I don't know how they can keep sustaining this policy of saying, oh, CPT is not allowed. Then why are the schools giving it? The schools speak for the USCIS, right? *5 if you have a follow-up question on this. *5. So my advice is to go ahead and apply for a change of status to H1B premium processing. Okay, this question comes to us from Columbus, Ohio. Ohio, go ahead, please. We can hear you. Ohio. Hang on, sir. Your voice is not very clear. Can you pick up the phone, not be on the speaker? Hello?
Is it clear now?
Much better, yes, thank you.
I understand that my employer has applied under the consular processing, but now, since you have mentioned an option that we can refile the H1.
Right.
So, since I'm having a new job opportunity, can I go ahead and file a transfer or amendment, like with the new position for the new position? So, if with the current employer, I think I should be filing an amendment.
Okay.
But if I look like transfer to a new employer, then is there a possibility? Can I file with a change of status for that?
Okay, this raises a couple of interesting issues. First of all, can you ask your current employer through whom you have an H1B approval not to revoke your H1?
Yeah.
Good. Because
if my current employer is having with them, yeah.
Okay. Because if they don't revoke it, in any case, they are not bound to pay your wages till October 1st. You are a quota case. In any case, you've not received a change of status either. So they should have no obligation to withdraw the case. They don't withdraw the case. You can transfer over to another employer. And if you are still maintaining student status, you can get a change of status from F1 to H1 within the USA. Yes. Okay. Good luck. Good luck. Okay, excellent. Next question. This is about, it's also another frequently asked question from Roop Raj about AC-21 portability of the Green Card and Supplement J. He changed his job recently, has to file a Supplement J. Couple of questions. Should I wait for an RFE before I file Supplement J? Guys, in most cases, I like to file Supplement J because it gives you additional protection. So there are very few cases where I've held back a Supplement J. Only cases where I've held back a Supplement J is where my client tells me, Rajiv, I'm not going to be able to stay with this employee more than 4 months or 5 months. then I don't want to waste their time and money filing a supplement J. But if you intend to stick around with this employer, file supplement J as quickly as you can. Don't wait for an RFE. Will USCIS issue an RFE automatically? Yeah, probably. The SOC code, systems analyst and software developer, tends to be close enough. I am more concerned about the job description. Think about it. In technology, a systems analyst does 3 things that a software developer also does. So a system analyst does do elicitation of the system requirements, technical as well as functional. They do assist in some sort of system flow, so some sort of design documentation, whether it's flow charts, etc. And third, they are involved in QA and review of QA. That's what software developer does. So these jobs tend to be quite close to each other. The only difference is that software developers sometimes get involved in coding, but they're always involved in design. So, but in other than that, their jobs are the same. So I don't think it's a question of this being too far apart, but really what I need to look at is the job descriptions. It isn't the job category because the categories are too vague. Have your lawyers assess that. As long as your situation is covered by same or similar, you're fine. *5, if you have a follow-up question on this, *5. Okay, there is one. This is from area code 562. Area code 562, where are you calling from?
I'm from California.
Yes, sir. Go ahead.
Rajiv, my case is similar to the case that you're talking about. My priority date has become current in latest visa bulletin, and I changed my job a few weeks ago. And my new employer is in process of submitting supplement J. Now the problem is we just have a couple of weeks before, most likely my 485 will get approved. So
I think you're okay. I think you're okay. I'll tell you what. Because what is supplement J? There's no mystery to it. Supplement J is simply a job offer. Okay. So when things become so close, you just change jobs and then the green card got approved, just make sure that the supplement J is prepared. Because if tomorrow it comes up, not tomorrow, but actually 5 years from now it comes up when you do your citizenship, it's very easily provable that you took a same or similar job. Supplement J is not a part of the legal requirements per se. It's not a part of the statutory requirements, but that's what the government requires procedurally. So therefore, if you're not able to file it on time, don't worry about it. I would still send it in if I were you and keep proof of the mailing, and I would definitely keep a copy of it for my records.
So you're saying that we should go ahead and file it?
Absolutely. Absolutely. That's okay.
What if in first week of say July it gets approved? Can you send it after that? Will it make sense?
Not after. Once you've received approval, no. But as long as you have not received approval, you can send it in. If you receive the approval, just keep a copy of it showing that it was ready to be filed.
Got it. Thank you. And just one last thing. Will filing supplement J delay the 485 approval?
Theoretically it can, but it probably will not. It's hard for me to comment about that. But I don't think it's a good idea not to file usually. But I don't know. In your case, I'm ambivalent. A part of me doesn't want to file it. A part of me says, well, let's just file it anyway. So it's really discuss with your lawyers what they feel about it. I'm actually okay either way. Since you're so close to the edge and the government has not asked for it, the law doesn't require me to do it unless the government asks for it. The only time it could become a problem is the naturalization. If I have a copy of it prepared and ready to go, that should be sufficient to convince the government at the naturalization stage. So it's a 50-50 question. I am not sure I have a strong preference for one or the other. Okay.
All right. Thank you.
You're welcome. Good luck. Next frequently asked question. Yes, this is interesting. It's a question that comes up quite frequently. I want to talk about the entrepreneurial H-1Bs. Basically, the idea is that I have an H-1B, but I also own the company. And the key there is that you must have an employer-employee relationship. So if there is somebody or something in the company that can fire you, for example, the board of directors, then you are okay to file the H-1B for your own company, but make sure you make it very clear to the government that you own majority stock or even maybe 100% stock of the company. But the less stock you own, the better are your chances, because the government could question at some point, well, if you own 100% stock, then you can also fire the board of directors. And it becomes a little bit more complicated, but so far, government has restricted its inquiry to the level of the board of directors. Can they fire you? If yes, okay, you can get your H-1B. For the L1, yes, L1 requires only that you must have worked outside USA for 1 year for a company related to this company that you are going through. So it can't be just because you are a managerial level employee now, you get an EB1C or an L1. You have to actually have 1 year of work outside USA. And it's 1 year out of the last 3, but there are limited exceptions to the last 3. If you are working for the same set of companies, let's say, for example, on H-1B, that 3 years is counted from the date you last entered. So let's say I entered IBM Canada, IBM USA. I worked for IBM Canada for 1 year. Then I entered to work for IBM USA on an H-1B, and I worked for 4 years. They won't count my 1 year in the last 3. They'll count it from the date I entered. So there's a very fine exemption created there. And for the H-1B that is through the entrepreneurial process, it's just like any other H-1B. You have to go through the lottery process, no question about it. And I don't like the L-1B visas, frankly, because it leaves too much in the hands of the government. L-1As are usually more clear-cut, but do remember you have to have worked for a related company outside the USA for 1 year. *5 if you have a follow-up question. *5. Okay, this one is coming to us from my neighborhood, Washington, D.C. Washington, D.C., go ahead, please.
Hi, so just to clarify on the L1, you have to, Canadians, I would have to work, say, at Mars, Canada for 1 year before they could bring me on an L1 visa to the United States. Is that correct?
That is correct. And actually, I have so many clients who have done that and already doing it. We have one client who's doing it out of UK. We had just filed their L1 and then this Trump calamity struck. We have another client who did it out of Japan. Mm-hmm. So a lot of people are actually physically planning that as a part of their US immigration strategy.
Got it. Okay. So, but this would be like, so if I apply for a new job, I'd have to apply for it in Canada first with a major company and then look to come back in 1 year after things open up again.
Right. But there is only one caveat. It doesn't have to be a major company. The H-1B I've done, the smallest company I've done for had only 5 employees. 6. 3 in India, 2 in Singapore, and 1 in USA. All Wharton graduates. A very specialized company, but it depends upon the kind of job you have. Read up on the definition of what is managerial or executive. There are many nuances there. If you have a job that manages other professionals, that's very simple. But if you have a job that is functionally a manager, but not a people manager, it's more complicated. So what I would suggest is when you get a job located, make sure you talk with the lawyers who would be helping you eventually to plan it. But definitely it can be done. A lot of people are doing it.
Got it.
Okay.
Can I ask you a quick question about the B2 that you had emailed me?
Oh, yeah, I remember your email. Go ahead. Sure. Why not?
Thank you. So you had recommended that I was on a TN. My 60 days is just coming up. I was just concerned about traveling. The borders are still not open. You had recommended that I submit a B2.
Right.
And my question is, let's say in a month, I do want to go back to visit family. How does that impact me applying for a B2 this week?
If you leave the United States, that B2 is deemed to be abandoned. But you as a Canadian, and I have not looked at the Customs and Border Protection answer on this, but they have said very clearly that Canadians are not subject to the Trump rules. So you could actually come back on H-1B, TN, anything you like.
Oh, okay.
Yeah.
Well, that's good news.
Yeah, that was yesterday. Late last evening, I heard about it, but I was too busy trying to get my 3 hours of sleep before. So yeah, no, I think you'll be fine. I double check on the CBP website. You have so many options. I like the idea of applying for a B2 because for $600, that the filing fees, you buy peace of mind. Nobody can say, well, you're unlawfully present.
Okay, so even if I wanted to stay for another 3 weeks, you think it's still worthwhile to file?
Not 3 weeks. I will not spend $600 for 3 weeks. But if it were maybe a few months, 2, 3, 4 months, I would definitely file it.
Okay, no, I'm just looking to stay until the borders, are open and a little safer to travel, which would be like maybe another month or.
Yeah, that I would file because you don't know when the borders are gonna be open. Because if you look at it, this morning there was a news that U.S. travelers are going to be, or at least they are thinking of banning them in Europe because we've not been able to contain our coronavirus situation here. So we don't know when these borders are going to open.
I see. So thank you. So if I apply, but as soon as I cross the border, that B2 we considered abandoned, and then I would have to come in another B2 or another visa going to come back.
Yeah, it's not an issue at all. If it's abandoned, it doesn't hurt you. It doesn't matter at all.
Okay, thank you so much for everything you're doing.
You're very welcome. One quick thing, just remember to keep copies of your application just in case that issue ever comes up.
Okay, thank you.
Oh, you're welcome. Good luck.
Thank you.
Bye. Okay, guys. Let's see. So, Snehshri wanted to know. Namaste ji. Namaste, ma'am. 60-day grace period of H1B is getting over. I want to get on to F1. So theoretically, yes, that's an option, and it's as good or as bad as an option as a tourist visa. The only problem is, as you might have heard me say earlier, that you're always chasing a time period which is very, it's fluctuating because the government takes so long to decide the case. So under the law, you have to maintain your status up until 30 days before your semester begins, right? Because if they approve your F1 today, you must be able to join school within 30 days. So if you are 3 months away from the next semester, by the time they decide your case, you can no longer get an F1. So it's a race to the right time and the right. You have to keep extending your I-20s. Talk to the school; they'll be able to talk you through the problem. Everybody knows what the issue is. That's my only problem with F1. So I would rather have you do a B1, B2. And if you want to go to school, it's a little difficult for me to tell you what to do. But there is that problem of chasing the start date to be within 30 days of your status. Okay. Coming back to your questions, is it safe to change to F1? Yeah, it's as safe as B1, B2. Does it have to be? It has to be a genuine case, Snehshri. I don't like the idea of filing for something that you're not serious about. So if you already have a master's degree, why would you join a community college? So I think it has to be a genuine case. If you're really interested, for example, if you have a degree in information technology and you want to do some additional work in data science, that I can understand. But to step into a totally different direction, I don't know. As long as it's genuine, do it. And you don't really need us. You don't need a lawyer for these cases. Thank you for thinking of us. These change of status applications, I would only get involved if you need help with an RFE. As long as you are truthful in explaining your situation, follow the instructions on the forms, you're okay. Don't really need us for that. Then you had an ongoing question I meant to ask about degree level requirements to go from H1B to F1, then if one gets an H1B, back to H1B again. All of this is possible. And you can go to school part-time. There is no problem. On H1B, you can work full-time or whatever the terms of the H1B are, and at the same time go to school. We have clients who've done this. We have clients who've gone from H1 to F1 back to H1. Absolutely. They can. Government is not predictable in what they can ask you. But obviously, if you cannot leave the country, that's a very good reason to ask for a B2. Or even if you prefer not to because of the pandemic situation, or if you have a health issue, I think it's a good case for a tourist visa change of status. And then Shiv had some questions that were related, so I combined these two. To maintain status, if one changes to B1, B2, and from H1 then back to H1B, do you have to step outside USA? And the answer is not if your B1, B2 is already approved on the date your H1B is approved. So if you're on the date your second H1B is filed and it's still let me rephrase that. Your H1B comes up for adjudication and your B2 is still pending, they will ask you to go outside because they don't consider that to be full status. Although we have one lawsuit last week on this, well, not one, but settled on this status issue. And we are filing another one I'm hoping this week, because we just got retained for that, in which what happened was this gentleman has an H1B extension pending. During the extension, he changed over to a new employer, but past his 60 days. Extension is still pending, but his original I-94 has expired. The government gave me the H-1B for the second case, but they declined to give me status. I intend to sue the government and say that, okay, we understand. You have this policy that when somebody's status is still pending, you don't consider them to be in full status. But this is a circumstance in which you should exercise your discretion. So, in other words, we are going to challenge their non-exercise of discretion to give me status. And that's a tough case to win, but you never know. I think this is such a sympathetic situation. You've got the COVID going, you've got a guy who's lived here decades, and he's obeyed every law of this country, and now you tell him, go outside USA. Oh yeah, by the way, you can't come back because Trump imposed another ban. You should consider all these things to arrive at a conclusion that these are sympathetic circumstances. Okay, so I would say that when you go on to B2, if it is not approved, you do have the risk of having to go outside USA. Is H1B for each employer? It's actually 60-day grace period is for each petition. So let's say you did an extension last year and you took advantage of the 60 days. Then you did an amendment, you again have 60 days. Can you get unemployment benefits? The answer is yes, if the state law allows it. And it should not impact your future immigration status. *5 if you have any questions on this, guys. *5. Any questions on this? Okay, I have one from 312. 312, where are you calling from?
Birmingham, Alabama. This is Suresh Kumar Samayamantal.
Anji Sureshi, how are you?
Yeah, I'm okay. My 60 days is starting today.
Okay.
So from today.
Okay.
I've been in this country for the past 15 years.
Right.
So 140, you have taken up my case as well many times, and you've talked on the email as well many times.
Oh.
Just wondering, if I take the B1, B2, because the telecom industry is going bad, and now I have for my kids, I have to stay here.
Hang on one second. Hang on one second. Did you say your B1, B2 is also, your I-140 is also approved?
With 3 companies. I have my priority.
Okay. What I would have you do is probably also look at extraordinary or compelling circumstances EAD. Okay. Compelling circumstances EAD says, if my I-140 is approved and my priority date is not current, and for some reason I cannot do a regular case like an H-1B, etc., I should be given an employment authorization. I believe it's on an annual basis to continue working until my extraordinary circumstances don't change. Not only you, but your wife can also get an EAD under that. The only problem is, what if you get denied? So you could combine it. You could combine it with a B2 and a compelling circumstances EAD. That would be the safest thing to do. So if you get it, great, because I remember making a case for somebody. We've done a bunch of these, mostly on health grounds. Either of the person, for example, I had a physician who had a very serious spinal problem. I don't remember if we processed his case or he did that himself, but I remember consulting, and that worked out. We had a guy who had back pain, couldn't sit for long periods of time. It came and went. We were able to get a compelling circumstances EAD. Another guy had gone through some surgeries. Another guy had a child with medical issues, and the wife didn't have a driver's license. So the working hours were irregular. So you can look into that as well. But I would say file B1, B2 if you're not able to find a job.
My case is I'm divorced and I have my dependent kids.
It's a very
India in 60 days I cannot come back.
The kids are in USA with you? You have custody?
Yeah, they are US citizens. I have custody week on, week off. And
I think
if I have to leave, then I cannot.
Yeah, I think compelling circumstances EAD, but combine it with a B2, Suresh. Kumar. I don't know what your first name is. Is it Kumar or Suresh? What is your first name?
Suresh.
Yeah. So Suresh, what I would do is I would go ahead and combine with a B2, file a B2, and then file a compelling circumstances EAD. I think you have a good case for it.
Okay.
Now, with that EAD, I just want to point something out. You can work 1 job, 2 jobs, 10 jobs outside your own field. It doesn't matter. Okay. So
then I'll reach out to you.
If you have my email address, absolutely. Reach out to us. Yeah. You can email me at help@immigration.com. You said you've talked with.
You recently replied back to me saying that only option is B1, B2. So,
no, because now that
compelling is.
That's the problem. When you are talking on email, I only know the framework of what you asked me. But when we start talking, there are so many other options that come up.
Okay.
So
I'll officially schedule a time with you, and then we can take it up from there.
Absolutely. You won't need a time with me. I understand your situation. I will have somebody in the team work with us and prepare a case for you whenever you're ready to go forward. Okay. Good luck.
Sure.
Good luck, sir. Bye-bye. Okay. Now, there's another question. 1 second. Sorry. This one is from Pennsylvania. Yeah, Pennsylvania. Go ahead, please. We can hear you.
Yeah, hello, Rajiv. This is Neeraj. So just a follow-up question on that one. So you said about this compelling circumstances EAD. Now, as Suresh was discussing his case, just to brief you, my case is that I just have one I-140 approved 2.5 years ago, and I have lost my job 20 days ago. So in that case, if I'm going to take the B2 route instead of just going with the F1 and just stick with B2, should I also try this option for?
Absolutely. You know what I would like to do is I would like to be paid for our time for one case, and then everybody who's out of a job use the same template. because the idea is the basic factors in every case are the same. Look, I've lost my job. I cannot find a job. I would appreciate, see, I don't know what the government's attitude is going to be in view of the clown in the White House, who every few days comes up with some new nonsense. I can very much sympathize with the loss of jobs, but the problem is you are putting apples, oranges, and bananas in the same basket and throwing it all over into the ocean. Okay. I want to know, are there jobs that have been lost in the technology industry? If yes, how many? And if how many, in what skills? Because you can't think of a Java developer doing .NET development. It's not that easy, especially at senior levels. And each skill set is different. So I don't know. I think these guys basically, because most of the people who vote for them are illiterate, they treat them accordingly and they make decisions accordingly. Most of them are themselves functionally illiterate. Trump did not know so many things. He makes up names of countries. He doesn't know where Nepal is. All these things are documented. These guys don't know what they are doing. And you are hurting because of that. So that's the only thing that's the bad part. We don't know how the government is going to deal with these things. But I think loss of a job is definitely something that should be brought up, and maybe that will work for you. In any case, you have a B2 in the background that protects you. So it's an adventure. If you lose, you lose.
Right, I see. And then in that case, we have to attach like employer letter, like why you were
No,
and all that.
no, I wouldn't do that. See, I have to decide what is a compelling circumstance here. And I'll give you an example. I don't remember whether I did this case or I give consultation on this. Somebody was living in a small town, okay, and they had kids going to school there, and they were doing SAP work, and the company that they were doing SAP work went out of business. Now, in that town, within a 150-mile radius, there were no SAP jobs. Okay. So at some point, we then approached the government and said, look, this is a situation where he can't even get a job in this industry and can't move because of the children. So I think he did get his employment authorization. So the idea is that in relation to the job, there have to be factors that make it so that, like I said, it's compelling circumstances. I actually, if you go to my blog, a couple of years ago when this provision first came out, I think in 2017, I made I like to believe, a very good information map, which tells you everything you need to know. So you go to my blog on immigration.com. Its link is on the top as well as on the bottom right. And you go to, I think it's under separate heading called compelling circumstances EAD. But look around and you should be able to find it. Review that map. In fact, share it with other people as well if they want to see it. I think I did a pretty good job preparing that map. It sums up the entire law in 1/2 of a page. Okay?
Oh, nice.
Yeah, follow that through.
Okay.
Good luck.
So sure. So then in that case, I mean, like you said, change of status, we can always do. I've been a student here in the US, so I filed EADs. But in this situation with compelling circumstances, I think we can still avail your services, right?
Oh, absolutely, absolutely. We'll be happy. I mean, you can hire us even to do the change of status, but it's a waste of your money. I don't create value for you. In compelling circumstances, EAD, I definitely create value because I make arguments for you. But for B2 change of status, I don't know what I can do for you. So it's
right, and especially that I think these days they made it online too, so it's even more convenient.
Exactly. So that's why where we can create value, we welcome your business. But where we cannot create value, we think it's a little, I don't know. It's unfair to take your money. That's put it that.
We appreciate. We all appreciate that.
Absolutely. You're welcome. Good luck, sir.
Yeah.
All right.
Yeah.
All right. Bye-bye.
Yeah, bye.
Okay. So let's see. This is also a question that has come up quite a few times. should I amend my H-1B for remote work from home? And the answer is, well, that depends. First of all, there is a little provision, and I'm not sure how well that is applicable to this situation. There's a provision in immigration laws under the Department of Labor regulations where you are allowed to work from non-work sites, which means non-LCA sites, for up to 30 days in any one 12-month period. So let's say in a 12-month period, I worked 20 days in Washington, D.C., 25 days in Cleveland, Ohio, 23 days in Denver, Colorado, but I was approved for Seattle, Washington. That's okay, because in one 12-month period, you worked in one area only for 30 days or less for a non-LCA approved area. But government has said that if you misuse that provision to do short-term projects, we're going to come after you. So that's a little difficult to apply to this situation. If we had to, we probably could argue. But the way this works is it depends upon the geographical location. If you are working within normal commuting distance of an approved LCA location, you do not need an LCA, or you do not need an H-1B amendment. You just need an LCA posting. So if you were approved for, let's say, New York City, but you are living in Long Island, if you're approved for Manhattan, you're living in Long Island, that's not too far. That's normal commuting distance. Government has said 50 miles or so is normal commuting distance, but I have one cases where the commuting distance was almost 100 miles. I think it was like 85, something like that, because we were able to prove that people from that area commuted to work every day to the job location. So normal commuting distance, if your home is within normal commuting distance from the approved LCA site, you are not required to do an amendment. You just have to do an LCA posting at your home. And I doubt if that's even necessary, but do it anyway. It doesn't cost you anything. If, on the other hand, the distance is more than that, then you should do an H-1B amendment. Is there any other option I should avail instead of waiting for EB2 India? I don't know. I don't know all your circumstances. If you have an EB1A option or a possibility, or EB1C, EB1A is when people are extraordinarily qualified. EB1B is when they are professors or researchers. EB1C is when they are international managers who have worked outside USA for 1 year. The good thing is you can transfer priority date from EB2 to EB1. We've done EB1As successfully for a bunch of technology people also. But we have to assess each resume, and you truly have to be the top 5-10% people in the country to achieve the EB1A honor. It's not a simple filing. It takes considerable work, okay? Star 5, if you have a follow-up question on this. Star 5. Okay. So let's see if there's any other there's another frequently asked question. For a part-time H-1B. Yes, H-1B can be for part-time jobs. I had a case, and I always quote this, 2 cases I always quote. One was for a physician who just needed a 10-hour part-time H-1B, and he was making $220 an hour. So that was what, almost $8,000 a month, more than that. So normally what happens is, if you are doing a part-time H-1B, government wants to make sure you can sustain your livelihood, your budget. Sometimes we even have to give budget, $300 for grocery, $200 for gas, $600 for rent, whatever. So we have to create a complete budget sometimes to prove to the government, or if you're living with your brother, you don't have to pay rent, or your spouse is living with you, she also has a job. All those things can be taken into account, but H-1B can be for part-time. Not only for part-time, it can be on a sliding scale, 20 to 40 hours each week, for example. Okay. Another case I give example of is somebody who had 3 concurrent jobs on an H-1B, and government questioned us. We were able to show that he can do 3 full-time jobs is because he gets paid full-time, as a top-notch database administrator. He only goes in if there's trouble. He is just on call 40 hours each week for 3 companies. So that's an example of how these things work. Well, you can do a job for a level 2. You can't negotiate levels like that. We have to look at the job description. But if it's a routine professional job, it falls in level 2. And they shouldn't do this, that they make you work more hours and pay you for less. That's illegal, and don't be involved in that. Okay? Star 5 if you have a follow-up question. Star 5. And you are very welcome, sir. It's my pleasure. Okay. And Snehshri was helping somebody out. Thank you, Sneh. Then we come to the next page also. Or did I cover? Hang on one second. I just thought of something. Wasn't sure I covered all the questions. Part-time H1B. Yeah, okay. I think that's covered. All right. Let's go back to our next page. Doing business on OPT. Now, when you are on your first year of OPT, not STEM extension, you can actually work for yourself. That's legal. What is the process of starting a business on OPT? You should begin by asking a generic question. What is the process of starting business in USA for anyone? And once you answer that question, then the fact that you're on OPT doesn't make that much of a difference for doing business, but it makes a difference, as you noted, after your OPT extension ends. Not OPT extension, but OPT ends. Can I continue running a business? You can have 51% ownership, but you cannot run the business. You can only be a passive partner. My wife is on H1B. Can I continue being an owner on H480? Yes, you can. How practical does that seem? Well, so far it hasn't. H480 is not gone anywhere. So anybody's guess is as good as mine, whether it'll be around tomorrow, but it's around today. So you can plan for it. Otherwise, you'll have to move to a passive status. Star 5 if you have a follow-up question on this. Star 5. Okay. So let's return to our normally scheduled program, which is the non-frequently asked questions. So ST29 had first asked me they wanted to travel separately. They are on IR5, which means they are the parents of a US citizen. I've decided against traveling before my immigration visa expiration date. How do we? Actually, if you go to the consulate website and also in our own forums, there is a COVID-related forum where I have posted links to what the consulate said, how they will renew your immigration visa. That link is on our COVID forums. Under Rajiv's corner on the very top, there's a COVID forum where I have answered this question. Okay. Star 5 if you have a follow-up question. Yeah, you don't have to restart the paperwork. They should be able to simply renew the visa. Okay, there is a follow-up question on this. Let's see, this from Pennsylvania. Pennsylvania, go ahead, please.
Yeah, Rajiv, actually, the follow-up question was the last time, the last question, I mean. The second part of the question is basically trying to understand is like what is it a good chance that even a part-time employment for level 1 get approved, or is it a better chance that if level 2 is qualifying, like you said, it depends really on the job. If it qualifies for level 2, then is it better that it might get approved for level?
Hang on, there is a fundamental misunderstanding amongst people what are level 1, 2, 3, 4 jobs. They are not something you can negotiate. That would be fraud. Basically, you look at the job description. If it looks like a job which is entry-level job for people who are just out of school, they are still learning how to do things. They are closely supervised. And if they are given any relatively advanced duties, they are for developmental purposes. That's a level 1 job. Typically 0 to 3 years out of school. Level 2 is routine professional jobs. Level 3 is more advanced. And level 4 is almost somebody who's a technical top guy, subject matter expert. Even at level 3 and 4 are hard to distinguish. But level 2 is routine and level 1 is entry. So if your job is level 2, you can't negotiate it down to level 1.
Okay, I see. So they should just go for, if they don't have enough work, they can do part-time at level 2, right? Basically.
Yes, sir, they can. And they can also do part-time in the sense level, for example, 20 to 40 hours.
Oh, okay. I see. So between 20 to 40 hours, they can adjust. Basically.
No, they can do a sliding scale approach. We are going to file an H1B, number of hours 20 to 40.
Okay, I see.
So then they are obliged to pay you for 20, but not for more than 40.
Okay, right.
Okay.
Okay, makes sense.
Good luck, sir.
Yeah.
Okay. So we did this one. HPS says my I-140 is approved 2012, 7th year extension. I'm in India since 2017. If I file H1B in 2020, will I be cap exempt? Yes, you will be. You will not be under the quota. Star 5 if you have a follow-up question. Star 5. Next question is from Nevas. Reentry permit is expiring on July 27th, but they visited in August 2019. Should I return to the US before my reentry permit expires? I would prefer that, sir. Can I plan to arrive by August 25th, 364 days from the last date of exit? I think you should plan on coming in July. Otherwise, yeah, there is a possibility they could go after your green card. Although these circumstances are such, will they be able to make it stick? I don't know. But I avoid argument with the government where I can. But of course, if you have no choice, then come, and they are obliged to let you in. They can't keep you out. They can lift your green card and make you go through an immigration proceeding, which could take years, definitely many months. That's okay. If you're okay with that outcome, I think you should be able to convince an immigration judge, if they try to take your green card, that you had no option, you were stuck with this situation. You can assess that with a lawyer and go over your case in a personal consultation and make sure that you have enough to convince an immigration judge that if they try to take away your green card. But for 1 month, I mean, might as well come now. That's the way I see it. Yeah, you're only trying to get an extra few days. Might as well come in July. That's the way I look at it. Star 5 if you have a follow-up question. Star 5. Okay. ImiHelp84 says, my wife is working full-time on H4EAD. She got selected for H1B. She requested for consular processing and not change of status. He is filing premium, but he says she might get 9. No, why would she? If you clearly ask for consular processing, they should not give her an I-94. And your lawyers can put a colored sheet on top saying consular processing requested, And yes, you can ask them to change back without the I-94 if they make a mistake. Star 5 if you have a follow-up question on this. Star 5. Okay. This is from area code 315. 315, where are you calling from?
Hi, Rajiv. I'm calling from New York.
Yes, sir.
First of all, thank you very much for your service.
Very welcome.
I have reached a couple of times before also. Thank you very much for all service you are doing.
Yes, sir.
My second question is, let's say her employer, right? He's filing June in the June month, and he got the start date December, right?
change of status based upon the processing. So it's start date like December 20th or 15 something. So from H4 EAD, she will change her status on the first. I mean, I just want to know it will switch to on which particular day.
Okay, so I lost your conversation there. You were fading in and out. But let me try to understand what you said and you can correct me if I got it wrong. So the question is, if we ask for a change of status beginning December, when does she actually change? Is that what you asked me?
Yes, Rajiv, that's correct.
Yeah. So first of all, you can ask for a change of status only up to 6 months ahead of time. And if you have asked for up to 6 months, for example, in June, you asked for December, she continues to be on H4 until December hits. And then she is automatically on H1B if the change of status has been approved effective December. Okay.
Okay. Yeah, I got the clarification. Thank you. Thank you very much, Rajiv.
You're welcome. Good luck. Okay. So then the next question is from SR 2018. EB1 priority date is 2017. Concurrently applied. So this is the CSPA question. And I think, as far as I remember, once you have filed, even if there is a retrogression, she's protected by the CSPA. Now, I don't think it should be a problem. So from what I remember of CSPA, the race is to file the 485 before they turn 21, adjusted age with current age subtracting the time it took for the I-140 to get approved. If they are under 21, based upon that formula, when you file the 485, that's good enough. After that, even if the retrogression occurs, it shouldn't bother their status. Star 5, if you have a follow-up question. Okay. This question is from area code 803. 803, where are you calling from?
I'm calling from South Carolina.
South Carolina. Okay, sir. Go ahead.
Yeah, sir. Thanks, Rajiv, for all the community service you're doing. I think I've been listening for the last 1 hour. It's been very, very descriptive. Thanks very much.
My pleasure. My pleasure.
I have a question mentioned, and this is CPA related. When I applied for my EB1 back in 2017,
right,
the dates are correct. I applied for 485 as well as 140.
Right.
But by the time 140 is approved, the dates, retrogressed back in 2015. Then I was waiting for 1 year, then again retrogressed in the last year also. It just become a current in the July bulletin right now.
Mm-hmm.
So, my daughter was, minor when I applied for 485.
Yeah, she was 19.
Just turned 22.
Yeah, I saw that.
Yeah.
I think she's protected by the CSPA, sir. Because when you filed her 485, she was 19. And that's really our finish line. Once we have filed it, then we are good. After that, even if there's retrogression, there's no problem. Okay.
Okay. Another supplement question, sir. I mean, if you,
yeah, go ahead.
Yeah. The one issue, or probably now I just need your advice, is after applying, because of her studies, she has to go back, and we applied for advanced payroll or EAD, but she has to leave the country before the advanced payroll is.
Oh no.
Payroll is denied.
No. If she leaves without the advanced parole, her I-485 is deemed to be abandoned. It's gone, and there's no way I don't think she's protected for a CSPA under CSPA for an application through the consular processing.
We got her visa interview done, sir. We got a call from visa interview is also done for a green card.
Yeah, but until she gets an approval, that's not good enough, sir.
Okay.
Yeah.
Can we apply for consular process, sir, now?
No, absolutely not. CSPA, I don't think protects her from that case. So she'll be over 21 under CSPA for that. So she should wait until the green card is approved. Okay?
Oh, okay. All right. Thank you, sir.
You're welcome. Good luck. Okay. Next question is about a J1. And I don't remember how it worked. I kind of forgotten. I will have to look at my, I have to probably review the regulations. But I think there is a problem if after waiver you try to get back onto J1, that negates the waiver. I think so. Unless you change the status to F1. F1 you're okay, but if you try to extend your J1, I think, this is my guess, I don't remember the details, but I think your waiver could be your 212E could be reinstated. Yep, I think that would be a problem. Star 5 if you have a follow-up question. Okay. Let's see. This is from area code 602. Sorry, 608. 608, where are you calling from?
I'm calling from Wisconsin.
Wisconsin. Okay, sir, go ahead.
Yeah. So I reached out several immigration lawyers, and they said like it's too risky to transfer USC visa from current school to new school. So what I did is since I'm on academic training, I asked the new school professor to give me a research assistant job in his lab, and simultaneously I changed my status from J1 to F1.
Oh, good. Oh, good.
Once I get approved F1, then I can start PhD.
Absolutely. Absolutely. Oh, you did the smart thing.
That's what I thought.
Yeah, you did the smart thing.
Yeah.
I think it's a controversial area. I don't remember because I haven't looked at it for a few years now. But I do remember looking at it and thinking, this is not clear cut. It's a problem area.
So, so I have the follow-up question. I'm just thinking here loud. So down the road, if I get a job within this academic training,
right,
and if I initiate the change of status, if I want to withdraw the change of status from USCIS, like from J1 to F1, is it possible to withdraw?
Well, it is possible, but then you would be out of status and you would have to go outside USA for visa stamping. That's the only problem.
No, but I still have academic training till July 20.
As long as you are within your academic training still, yes, you can in that time change your mind as many times as you like to change status to other statuses. No problem.
Okay, and my J1 is ends up in July 2021.
Okay.
How do you see up now if I file for H1B and if it gets picked up next year? How do you see the status between July to October within this time frame? Do I have to go back to India, or is it like something?
F1 makes sense because you're interested in PhD. Why not just continue with the F1? Okay.
I mean, I did get some other job offers during this time, so I'm just debating whether I should go for the F1.
Well, you see, right now, the way I'm looking at it, there is all the advantage in staying inside the USA and all the disadvantage in being outside USA. There's no restriction on an F1 visa, of course, but if the ultimate goal is an H1B, you go outside USA, you're not coming back. Who knows how long it's going to take, right?
Right.
So,
and typical timeline for the J1 to F1 change of status.
Yeah, I think that's the same problem. It's not what you're changing from, it's what you're changing to. F1 change of statuses seem to be taking over 6 months. How much more, we don't know, but they seem to be taking a long time.
Thank you.
Okay.
Thank you so much. I appreciate your time.
You're welcome. Good luck.
Thank you.
Okay, guys, what is the next one? Let's see. Varun says, I have an approved I-140 and H-1B since 2018. Switching jobs, also getting married by the end of 2020. Congratulations. Now, once I start my new job, my current employer will withdraw my I-140. See, you have nothing to worry about because once your I-140 has been approved for more than 180 days, it stayed approved for more than 180 days, you have 100% advantage of that I-140. You can carry the priority date to a new green card, which you will have to do, but you can also keep getting extensions beyond 6 years based upon the approved and revoked I-140 because it stayed approved for 180 days. So no issue at all. And you can also file your wife's H for EAD. USCIS has said that policy is quite clear. They let your wife take advantage of that 180-day rule as well. *5 if you have a follow-up question. You are still in the first 3 years of your H-1B. That doesn't matter. Your I-140 is approved. Right? If I remember the law correctly, double check the law on this, but I think that I-140 approval is all that is needed. It is not needed that you must be in your 7th year. Double check that. I'm pretty sure that's the law. Okay. Then the next question. Snehshri was telling Varun where we had talked about this earlier. Then we already did Snehshri's question. MKB3. Wife's H4 and EAD applications received by USCIS on March 26th and pending. We have not received biometrics. Raise a service request. It doesn't cost you any money. Can you expedite? Yeah. If you Google or search in whatever search engine you like, USCIS expedite criteria, it tells you what the criteria are. If you meet them, by all means, give it a shot. *5 if you have a follow-up question on this. *5. Okay, we have a follow-up question. This is from area code 732, which I believe is New Jersey. 732, go ahead, please.
Yeah, thanks, Rajiv ji.
You're welcome.
So, one follow-up question here. How long does it take basically for to get this appointment letter and all those things basically?
Well, last year we had
more than 3 months.
Yeah, last year we had filed 2 lawsuits for H4 EAD delay. One was for a 2-year delay, the other one for an 11-month delay. So you can imagine these guys have been trying to sit on these cases as much as possible. Technically, anything beyond 90 days is questionable, maybe even suable. But as a practical matter, I would say wait a few months, maybe 7-8 months before you consider a lawsuit. How long they are taking is highly uncertain. I can't give you a number. So I'm not going to be able to be of much help to you here. All I can tell you is there is no problem in asking for a service request and see what happens.
Okay, and it's regarding the expediting the request. Basically, 90 days is over, and my H1 is also approved. So, do you think will they consider as expedite request if we request online?
Why not? I mean, like I said, read the criteria, expedite criteria, and if you think that the case fits under one of those, absolutely try it. Why not? It doesn't hurt you.
It shows 5 to 7 months of normal processing, for Nebraska.
Right.
So currently, we have means more than around 3 months is over basically at this moment.
3 months, yeah. So 5 to 7, yeah. They probably will not entertain your request. If they say 5 to 7 months, they will say, well, that's our normal processing time. I don't know how far that will get you, but filing a lawsuit after 3 months is a possibility. I haven't done one that quickly, I'm not sure how the courts would look at it. Sometimes the government makes this argument, and they haven't been doing it recently, but sometimes because they've been settling cases, sometimes they make this argument that, well, if there is a lineup and somebody files a lawsuit, we approve their case first, they are taking somebody else's place. We would have processed somebody else's case first. And how is that fair, replacing one head with another, just because one head sued? So therefore, it's a tough decision to make. I think personally 90 days is too early, right after 90 days. But there are indications in the paperwork, in the government statutes, in the congressional statutes that tell you that probably 90 days is what it should take. However, the court may not be inclined to interfere too early. I don't know. We can try. Okay?
Okay, sure, Rajiv.
Good luck.
Thank you so much.
Good luck. Because I'm not going to have time for new questions. My apologies. Because we have run out of time. I'm already over a few minutes. And I got to go. Well, I guess we are done with the regular questions. Let me see how many I can do. Anybody has any question, press *5. Oh, hang on one second. I have one already up. Area code 570, that's Pennsylvania. Go ahead, please.
Good afternoon, Rajiv. Recently, I saw the Trump, put a ban on the executive order for the H1.
Right.
So, is it going for like a new H1 from India, or like any extension also is going to ban?
No.
For extension.
It does not apply to people inside the USA. Okay.
Okay. And how about the L1? Like someone applied L1 outside right now?
They can't come in. Yeah, we are looking into a lawsuit on that, so we'll see. Okay.
Okay, all right. Thank you, Rajiv.
You're welcome. Good luck. So I have 4 more people. So let's see how many we can get. Area code 646. 646, where are you calling from?
Hi, Rajiv. I'm calling from Los Angeles.
Yes, sir. Go ahead. What is the question?
Yes, I just wanted to thank you, first of all, for everything you're doing. It's so helpful.
Absolutely.
So we have a situation in where my wife, who I'm sponsoring, we have a delay in our green card filing. We had our interview and got approved, and since then we've just been in a black hole. So when we call to get information, they say they can't give us information due to a personal situation where they can't elaborate on. Before my wife and I met, she had filed for a U visa due to physical abuse in her earlier relationship.
Mm-hmm.
Do you think that might have a? Do you think that might have caused an issue?
Yeah.
Getting our
you emailed me. I remember your email.
Yes.
You see, the problem is it is difficult to predict what the grounds for delay are. And normally, when you have something in the past that might need investigation, they could delay your case. How did your wife enter the United States the first time?
She entered as a student.
Okay. How long did she go to school?
She went to school for 5 years.
Okay. Now, these are very good facts. These are very good facts because they tell us she entered the United States as a genuine student. She went to school. I assume she got a degree?
Yeah.
Okay. Then, did she, after that, go on to an H1, start working? What did she do?
Yes, she went on the STEM OPT.
Okay. Excellent.
And she worked she worked for that that department.
Okay. Was she ever interviewed about the genuineness of her U visa application? Did anybody come over, ask her any questions?
Never. It's just been pending for 5 years.
Okay.
When we went to our green card interview, it wasn't brought up. We were approved based on an updated medical exam, which we sent in, and we're approved on that.
Okay, and you said you really you thought that you could file a lawsuit. You can, if you want. I'll give you a couple of suggestions to look into. So normally the problem is government will say delay cannot be measured against what? You can say that, the statute says that 6 months is the normal processing time for a green card. Why are you taking so long? So your lawsuit can be based upon mandamus. It's called the writ of mandamus for violation of Administrative Procedures Act, APA violation, which requires the government to act with reasonable haste, and Congress has said that 6 months is normal. So you can try to file a lawsuit.
Okay, and so if if our file has passed through Los Angeles, Vermont, and the National Benefits Center, where it is now, I'm sending copies to all of them.
I would start by first of all suing the director of or the Secretary for Homeland Security, because everybody under him is automatically covered. So I would not leave out so I would definitely include DHS Secretary, the top dude in DHS and the top dude in USCIS, and try to locate the file, include that officer in there as well. So whoever is in charge of wherever the file is, but that should cover that. Okay.
Yeah, so our file started in Los Angeles, so I think that's Director Luna, so I'll include her.
Yeah,
I'll also have it sent to NDC and Vermont just to cover myself there as well.
Absolutely, you can do that.
I guess it can't hurt. Yeah,
it doesn't hurt. It's just an additional, just an additional set of papers being sent. No big deal. Okay.
Awesome. Thank you so much again.
You're
really
welcome.
Appreciate your help.
You're welcome.
We all do.
Good luck. Good luck. Okay. This is from our neighborhood, Virginia. Go ahead, Virginia. I can hear you.
Yeah, Rajiv, I am planning to file my H1 next month.
Okay.
But based on the recent memorandum, is that possible, without client letter, I can file my H1 based on the vendor letter, and I can get the chance of getting approval for 3 years?
Actually, I am inclined to even hold back the vendor letters. So, because now the situation is odd in that the government says we can't require a whole bunch of contracts, but if you submit them, we can deny your case based upon those. So it makes sense to me to hold back at least some of the documentation, but we still have to prove the existence of specialty occupation job. So maybe an end client letter would be a great idea. But that's something your lawyers should decide. That's not something I should be deciding, because it depends upon the overall case. In my view, under the current circumstances, if you're doubtful about a paper, don't submit it. Okay?
Okay, because the problem is the client is the letters for 1 year only.
Well, they don't even have to mention a time period. They remove the time period. Just mention the job.
Right, but they always do that.
Okay, then it's a judgment call your lawyer has to make. I can't make that for them. Personally, if I had a 1 year client letter, I would still submit it.
Okay.
Okay.
Okay, perfect. Thank you. Appreciate for your help.
Yeah, good luck. Okay, I think I have 2 more questions. All right, that's not too bad. We can do that. California, go ahead, please. I can hear you. California.
Thank you for picking up my question, Rajiv.
Of course.
So my I-140 is approved this week with another employer.
Okay.
Not with my current employer.
Sure.
So the thing is, my current employer is planning to file my H1B extension.
Okay.
This month. So since my I-140 is approved this week, I don't have the E number with me, and the future employer is not going to give me that. So when I file my H1B extension with my current employer, do I need to provide the E number on that? Because it asks for that, I think.
Well, I have done it in the past. Our office has done it without the receipt numbers. So what we do is we give the name of the employer who processed the H1B. We give your social security number, and we say that we don't have access to this document, but we believe an I-140 has been approved.
Okay, so my current employer has to mention that on that form.
Yeah, absolutely. Absolutely. Okay? Good luck.
Okay.
Good luck, sir.
Thank you.
Bye-bye. Okay, last question of the day. This one is coming from area code 224. Where are you calling from, sir? Area code 224. Where are you calling from? Okay, so I guess we have one more. They just raised their hand. All right, we can, I guess, skip that. Area code 805. 805, go ahead, please. Where are you calling from?
Yes. Hi, Rajiv. I'm calling from Illinois.
Yes, sir.
So actually, I had posted questions on the thread, and question number 6, I was not able to join in time. So my son is actually doing engineering in Chicago.
Yeah, I've already answered that question. Just wait for the recording.
Okay.
Okay. I've already answered that question in quite some detail. Wait for the recording. You still have time. If it's not clear, we can always talk in 2 weeks. Okay?
Oh, okay.
Thank you. Bye-bye.
Thank you.
Yeah, folks, I don't have time to repeat answers, but we have recorded them, so don't worry. You're all set. I'll see you again in 2 weeks, everybody. Stay safe, and thank you for the opportunity to hang out with you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.